From the Solving Citizen Legal Encounters. All right, today we have a different type of case that's going on because we have a CEO that wanted to go pro se in a hearing where he owed someone some money. Here's the story. There was a couple that paid for a luxury trip that they wanted to go on, but for some reason it never happened, and they've been trying to get their money back for a whole year. So now we're at the time of a judgment hearing, and let's see how this is going to pan out. Let's go.
Kohler, I'm going to come back to you. And Mr. Sangrajka. Okay.
Yes, Your Honor.
So let me let you know a few things, both of you. Number one, I did receive the request for a continuance. I don't necessarily have an objection strongly to that, although I'll hear from Mr. Kohler about his position. The primary thing I need to let you know, Mr. Sangrajka, is that technically you're not allowed to represent Alluring Africa.
Yes.
Right, because
Yes.
you're not an attorney.
Right.
And so there's not really a motion for continuance in front of me. And the things that I have seen that you've submitted to my office in terms of your expressed concern about the nature of the service, and those other issues, and I think I saw something about an assertion of an arbitration provision in whatever agreement
Yes.
is alleged to exist. Those are all things I would expect to be asserted in any sort of filing, but at this point, none of those things are in front of me. So I just want to make sure you understand procedurally the posture of the case.
No, I do understand. I unfortunately, I didn't have an opportunity, a reasonable amount of time to retain counsel in Georgia. I do have, our attorney that we use here in Florida, but he's not licensed. So he's actually trying to help me secure representation in Georgia.
Okay, thank you. Mr. Kohler, what are your thoughts, sir?
Good morning, Your Honor. Again, Michael Kohler with Miller Morton. We object to any continuance. This is not a surprise to Alluring Africa. This dispute's been going on since the summer of last year. We got involved, notified Alluring Africa that suit would be imminent unless they followed through with their promise that they were going to refund the Hoffmans their money. They never responded to my letter, which was sent to their business address, which was sent to their email addresses. The sheriff's deputy down in Florida served them at their business address. And the default notice was sent to the same address that service was perfected in, which is also their business address. So none of this is just another delay tactic on behalf of the defendant. I never received, to the extent they have an attorney, I never received any communications from their attorney about this. And as your staff counsel, Mr. Freehoff, told the Alluring Africa that if they needed a continuance, they needed to get an attorney and they needed to file something with the court. They did not accept that invitation to do so. And it's completely improper for him to make representations on behalf of the company. He can't represent the company. He can't represent the company's interests. And so we prefer to move forward today. There's no basis for, I'm not going to get into the merits of these purported defenses, but I will say this, those defenses can be raised through a Rule 60 motion if they want to try to attack any judgment that's entered, but everything else is not properly before the court. And so our request, we had the Hoffmans on the call and we're ready to move forward with marshaling evidence to show the court how much damages is due in this case.
In this early stage of the hearing, it already looks bad for the defendant.
Okay. So Mr. Sangrajka,
Yes.
what Mr. Kohler says is accurate. And there are, I mean, if you ultimately retain counsel on behalf of Alluring Africa, your counsel would be, they could give you guidance on what steps, might be necessary to take or that you might choose to undertake. But the record evidence that I have in front of me, and this has nothing to do with the merits of the case, are that service was made on the registered address. I understand that you dispute that, but there is a return of service in the record that indicates that a law enforcement agency made service on the registered address on March the 24th, and that proof of that service was filed on March the 27th. Now, again, I understand that you dispute service, because I think what I saw, again, it's not properly before
Yeah.
the court, but I understand that you assert that there was a different unit that was served, and that unit is where your mother, who is not competent and or legally authorized to accept that service on your behalf. I understand all those things.
Okay.
But I'm just telling you what my record shows, right? My
Okay.
record shows that service was made on the registered address by a law enforcement officer who's authorized to serve process. That proof of that service was filed on March the 27th, which means that Alluring Africa's answer would be due on April the 28th.
Okay.
And that as of under Georgia law, Alluring Africa became in default immediately on that day.
Okay.
And that there is a period of time under Georgia law where Alluring Africa can open default as a matter of right, which is 15 days. And that time period has passed as of May the 13th.
It definitely looked like a delay tactic. Now, the judge said the address was registered to the business. Now, even though his mom may have some medical issues, that's the address. It went there. He knew it went there. They should have just dealt with it. But it seemed like they don't really want to pay this debt.
Okay.
And so all the record evidence that I have indicates that Alluring Africa is in default under Georgia law. And the only issue is one, what that means under Georgia law. Well, it also means that under Florida law. But what it means is that the well-pleaded factual allegations of the complaint are deemed to be admitted because they were never disputed. And in this particular instance, what Mr. Kohler has asked the court to do is to consider the issue of damages because some aspect of the damages that are sought by the Hoffmans is what we call unliquidated, which means that it wasn't a finite amount that was set by a contract or agreed account amount or something like that. Mr. Kohler, is this an issue where the contract damage is liquidated, but the attorney's fees are unliquidated, or is the entire amount unliquidated?
Yeah, that's a good question, Your Honor. I believe the contract amount is liquidated because they paid for services that they didn't get. They were promised a refund, so they're supposed to get their money back. So that's a finite amount. Obviously, our attorney's fees is probably the unliquidated portion of what we put up today.
Okay. And the reason I ask is because my recollection of reviewing in preparation for today's hearing, my recollection of reviewing the pleading is that there is a finite specific dollar amount asserted as contract damages, and that the amount, and if that is accurate and what you are seeking other than attorney's fees or interest, I don't know what the contract provides or statutorily, but if the specific amount of damages other than attorney's fees and interest that you're seeking is the amount that is listed in the complaint, then I believe that amount is liquidated, and you would be entitled to a judgment on that amount by default.
Yeah.
And then the only evidence the court would need to hear would be the claimed evidence of attorney's fees that were expended to recover that amount. Mr. Singrajka,
Yes.
what would happen now is that I would, as I have just said, based on the record evidence I have in front of me, it appears that the plaintiffs are entitled to a default judgment against Alluring Africa.
Okay.
At minimum, in the amount of the liquidated amount, I think it was $40-something thousand for the alleged travel costs that were paid, which again is deemed admitted. And then now what would happen is I would hear evidence from Mr. Kohler, however he wishes to present it, regarding the amount of any alleged attorney's fees that are raised. And so that's what we're going to do now in terms of proceeding. Do you, again, I understand that you dispute this. You feel like you've been caught without notice. I understand those things. I'm not trying to be unreasonable, but I do want to make sure that you understand that position, even if you disagree with it.
No, I understand what you're saying. What my question is, this is what you're proposing is a default judgment. After this, is there another procedure to final judgment or something like that? Or, do I still have an opportunity to retain counsel in Georgia?
Your Honor, may I object? He's seeking legal advice from the bench, which is improper.
Yes. Mr. Kohler, I appreciate that. So, Mr. Sangrachka, I can't give you legal advice. It's not
Okay.
proper. What I was going to tell you, though, is the same thing I said a moment ago, and I think Mr. Kohler even said it. If you retain counsel, your counsel can give you advice about what
Okay.
steps you might take to attempt to protect your interests. All I can tell you now is that where we are now is procedurally proper.
Okay.
And so we're going to go ahead and proceed and allow the Hoffmans to provide evidence of the unliquidated portion of their damages. Mr.
Sure.
Kohler, how would you
Yeah.
like to do that, sir?
Your Honor, what I'd like to do, I agree the 48,000 and some change is liquidated, and I think that's deemed admitted. We've also asked for prejudgment interest, and I'd like to just put in a little bit of evidence of when that interest started running.
Okay.
And with that, and then I'll get into the attorney's fees if the court doesn't mind.
That's fine. The reason I asked about how you're planning to do that, if you're talking about interest, that's probably something you're going to need to call a witness for. As in terms of your attorney's fees, you can state in your place, or you can have your client testify regarding those issues.
Yeah, attorney's fees, I'll just state in my place. I will like to introduce Mr. Hoffman. He's on
Yes,
the
sir.
call right now. And
Okay.
Mr. Hoffman, if you could raise your right hand. And
Good morning, Judge.
Mr. Hoffman, good morning. Can you please raise your right hand, sir? Do you swear that the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may lower your hand. Go ahead, Mr. Kohler.
Thank you, Mr. Hoffman. Mr. Hoffman, please introduce yourself to the court.
Christopher Hoffman, and I'm here with my wife, Creighton Hoffman.
Okay. And Mr. Hoffman, at one point in time, Alluring Africa agreed to refund your money that you spent for a vacation in Africa. Is that right?
That's correct.
Okay. And I'm going to put up on the screen an email here. I want you to see if you let me know if I'm able to share my screen, if you see my screen there.
I do not see your screen, so I don't think you're sharing. You're free to do so, but I don't think you are until now.
Okay.
Okay, go ahead.
Mr. Hoffman, do you see my screen there?
I do.
Can you identify that for the court, please?
Yes, that's an email that was sent from Alluring Africa to my wife, Creighton Hoffman, at her email address stating your refund is in process.
Okay. And do you know what the date is on that?
The date is July 1st, 2024.
Okay. All right. And Your Honor, the point of showing that is when the proposed order we submitted to the court, we ran the interest back to that date. That's the date that they promised to refund the money. And it obviously hasn't happened. Otherwise, we wouldn't be here today. So when we calculated the date under Georgia law, it runs at 7%. So we just added up the days since then to calculate interest.
With 7% interest, I'm sure that's going to be a whole lot.
Thank you. So I have a copy of your order, Mr. Kohler. Can you tell me though that date is not in your proposed order, and I'd like for it to be? Can you tell me what that date is?
It is July 1, 2024. And I think it may have been, I think in the motion that we.
Oh, it was. It's in your motion. It just wasn't in the proposed order that I was reading.
I got you. The amount of interest owed through today would be $3,059.72.
Yes, that's what I have in the proposed order.
Okay, good. My math's right. So, Your Honor, we've established through the default that the principal amount of $48,493.16. The prejudgment interest should start accruing from July 1 of 2024. That amount totals $3,059.72. We've also asked for our attorney's fees in this case. Under 13.611, we've argued that the Alluring Africa has been stubborn, litigious, caused unnecessary trouble and expense. They promised to do the right thing, which in this case was to refund the Hoffmans. They memorialized that by way of email, and they didn't follow through on their promise. And the Hoffmans reached out to them multiple times. And when they were stonewalled, the Hoffmans reached out to me. I've represented the Hoffmans for a long period of time. I also represent Mr. Hoffman's company. So our relationship goes back a long time. I trust him, and I'm sure I hope that he trusts us. When I got this, I tasked one of my colleagues and associate, Raquel McKee, to kind of look at this, find out what happened, when it happened. And in November of last year, Raquel, after doing her investigation, sent out a demand letter to Alluring Africa. As I stated earlier, that demand wasn't responded to. It was met with silence. Miss McGee, she ended up going on maternity leave, and another colleague of mine at the office, Peter Kritikos, he stepped in. He's also an associate. He stepped in, drafted up the complaint, got that filed, retained, coordinated with the sheriff's office down in Florida, and got them served. And so my time that I have in this case, and I'm a partner at Miller Martin. I've been a partner. I've been practicing law for almost 25 years. I'm the head of our litigation group. I oversee about 45 attorneys. I'm responsible for setting our rates, and part of that process is knowing what the rates are in the Atlanta market, making sure our rates are competitive. And so I set our rates in the associates who work at my firm, including the paralegals. And the amount of time that I have, not including the time I have over the last couple of days, I have about a little less than 3 hours of time on this. I delegated as much as I could to keep the costs down to Miss McGee and to Peter. And they've got about 23 hours of time in the case, and paralegal time is a little less than 3 hours. Each month, as custom, I send invoices to the Hoffmans for the work we perform. Those invoices that we've billed total $13,674.37.
It would have been cheaper for them to pay this up last year.
I've got copies of those invoices that I'm happy to tender into the court's record.
Okay. Can you tell me, Mr. Kohler, what is, you told me the amount of hours that had been expended by the associates versus you. I apologize if you said it and I did not hear, but can you tell me a little bit about your normal rate and the normal rates that are charged by your associates?
Yeah. So in 2024, my hourly rate was $590. We adjust those rates every year. And so in 2025, my hourly rate is $630.
My hourly rate is giving me a thumbs up.
Miss McGee's hourly rate, she only performed work in 2024, and her hourly rate in 2024 was $430. And Mr. Kritikos' hourly rate in 2024 was $450, and his hourly rate in 2025 is $480. The paralegal who's been providing support on this, her hourly rate in 2024 was $275, and this year it's $295.
They have some heavily paid staff at that firm. Maybe I should be wearing a suit for this video.
Thank you.
And those rates are competitive with reasonably situated law firms here in Atlanta. And these associates I've worked with a long time. I trust them, and they do a good job, and that's why I asked them to provide support for me on this particular matter. I'm going to share my screen here now, and let me know when you can see that, Your Honor.
I can see it.
Okay, this is the first invoice that we sent out to the Hoffmans. This is when we were engaged in the summer of 2024. It was for $580. And this was kind of the start of the relationship when we first learned about this dispute. The next invoice that was sent was for $1,983.50. And this is Miss McGee performing her investigation to find out what happened and when, and started preparing a demand letter. The next invoice, not a lot of work done in September of 2024. This invoice was for $215. And the Hoffmans, we submit these invoices each month for work performed the prior month, and they pay. There's nothing outstanding on any of these invoices. They've paid them all. Next invoices was for $1,005. And again, this is investigative work and preparing demand letters and starting to prepare the complaint in this case. And the invoice after that was for $3,186. And each month I look at the pre-bills, I look at the invoices to make sure that the work was performed was reasonable and necessary. And if I don't believe those two things are met, I reduce the invoices accordingly. These don't reflect any reductions that were made. These are after any reductions have made. This is the finalizing of the demand letter that happened in November of 2024. And then the next invoice was for $680.76. And this is when Peter got involved after Miss McGee went on her maternity leave. And then in February of 2025, the invoice for $4,218. This is when we're drafting the complaint and getting the complaint filed and getting it ready to be served on the defendant. And then in the next invoice is for $1,114.50. And we tendered these into the court. We filed these with the clerk's office yesterday. All these are identified as Exhibit D, Part 2. Part 1.
It looks like I did locate them when I was reviewing. They were filed, I think, with a certificate of services document number 7 in my file. And you're right, they're Exhibit D. So.
Yeah, and I think, Judge, Part 1, I performed kind of a high-level summary of these that just identify the date, the invoice, and the invoice amount as a summary.
Okay, I will tell you if there is a Part 2, what I have as Exhibit D is just the summary table document.
Okay.
So it may be if there's a second one that it hasn't arrived yet.
Yeah.
But I'm able to review these documents. I'm familiar with legal billing,
Yeah.
and your outline of them is acceptable to me. Although obviously going forward, they should be made part of the record. So
yeah. So yesterday I did a notice of filing of Exhibit D Part 1 and Exhibit D Part 2. So those were submitted, I believe, yesterday afternoon. So those should be in the record, and we moved to tender these into the court's record formally.
Okay, they're admitted. That's fine. And as I said, they'll be part of the record more formally once they're accepted by the clerk.
All right. And the only thing that these do not include, these are the actual invoices that were submitted to the client and paid. They total $13,674.37. We have not billed the Hoffmans for the time we've spent in May. That totals about $2,880. And that's also an estimate for our time to prepare for today and our attendance today. So the total amount of attorney's fees is $16,554.37. And as I said, we believe those are reasonable and they were necessary to deal with this dispute, prepare the complaint, get the complaint filed, get the complaint served, submit the motion for entry of default, and plan to prepare for the hearing today. So we ask that the court award the Hoffmans their attorney's fees related to this dispute.
One thing I can say, that attorney came prepared for this case.
Okay. Thank you. So as I said, I had a chance to review the complaint. I do believe that the primary judgment amount sought by the Hoffmans in the amount of $48,493.16 is a liquidated amount that was admitted in the complaint. I agree with Mr. Kohler that there is a basis for seeking prejudgment interest as of the date when allegedly Alluring Africa agreed to provide a refund, which I believe has been represented to me as July 1st of 2024. So that unliquidated amount of $3,059.72 would be recoverable. And then having reviewed and heard the information from both the Hoffmans and from Mr. Kohler regarding both prejudgment interest and the attorney fees and expenses, it appears to me that the amount of time was reasonable and necessary under the circumstances, and that the hourly rates charged by Mr. Kohler and his associates are reasonable for the business environment and economic environment in which we work here in the city of, well, in the greater Atlanta metro. So for that reason, I believe that the amount of $16,554.37 that was sought by the Hoffmans for their expended attorney's fees is also reasonable and recoverable. The underlying finding that's necessary, which was a violation of 13.611, is admitted by way of it being a default judgment. And so for that reason, other Mr. Kohler than adding in a brief sentence about the running of prejudgment interest and the entitlement to prejudgment interest from July 1st, I am going to grant the default judgment in favor of the Hoffmans in the total amount of $68,107.25.
He definitely needed an attorney.
And Mr. Sangrachka, if and when that will be finalized, and if and when you retain counsel, y'all can take whatever steps you would like to. I suspect that order, the judgment that I will enter will be finalized today and likely entered today.
Okay.
Could be as late as tomorrow, but no, tomorrow's Saturday. So it could be as late as Monday, but it will likely be entered today. Mr. Sangrachka, any other questions or anything that you have from me before we adjourn this matter?
No, at this stage, I will be retaining counsel, and
Okay.
we'll see. From what what I've been told, that there could be some grounds for us anyway. But I will speak to our attorney.
Understood. Thank you, Mr. Sangrachka. Mr. Kohler, anything else from you?
Do you need me to submit anything else to the court? Do you need me to massage the proposed order? I sent it in Word format. If there's
No,
any-
I have it in Word format, and I'm happy to edit it myself to make sure that it reflects the order that I want to enter. So I don't need anything else from y'all. I'll finish that order, and it will probably get filed today.
Great. Thank you. That concludes my business. May the Hoffmans and you kind of be excused.
Yes, thank you all. You all may be excused related to this matter.
Okay. Thank you.
Judge.
So if the defendant gets an attorney, they have accumulated so many charges from attorney's fees and all the other things over the last year. It would be interesting to know how they would get out of any of that. But anyway, I hope you enjoyed the video. It was a little bit different today, but I wanted to just throw a spin on something. Since I saw a CEO going pro se in a heavy case like this, I think that would have been a big mistake. And if I was a CEO, I wouldn't have attacked it. I would have called my attorney. See you next time.